Welcome. You'll be surprised how many people, including environmental assessment practitioners, fail to limit the extent of their impact assessment to the scope of the application, and also fail to conclude an authorized activity within the period granted. So in this video, we highlight two very important aspects of an environmental authorization, that is its scope and validity period. We then conclude by explaining one's options should they fail to complete an authorized activity before the environmental authorization expires. Welcome. My name is Sean McGregor of ecoleges environmental consultants based in Mpumalanga, South Africa, and we're on a mission to empower all South Africans to protect their environment through the correct interpretation and application of our environmental legislation. So if you want to learn how our environmental law applies to you and avoid unnecessary and costly mistakes, if you want to increase your knowledge and skills to reduce your reliance on external consultants, if you are in need of mentorship, or you just want to earn CPD points for a professional registration, then you'll want to subscribe to this channel. You can do that by swiping your mouse over the logo to the bottom right hand side of your screen. And please, if you do know of anyone else who can benefit, you can help us spread this message by liking them. Thank you. We leave the series Call of Duty, and the title of this video is EA Scope and Validity Period. Our source of information or reference is the Department's EIA regulations and EA validity period explanatory document published in 2018. I'll include a link to that explanatory document in the description below. And should you have any questions regarding the subject, you're welcome to forward those directly to iq@environment.gov.za. The scope and validity period of an environmental authorization are closely linked and defined by the legal provisions provided in the amended EIA regulations of 2014. I will read some of those provisions to you just now. When I talk about the scope of a listed activity, I'm referring to its development and operational phases. And please remember that the scope of an activity determines its life cycle. So the life cycle will either be limited to development only, or it'll incorporate both development and operation. Then the rule is pretty simple. Any environmental authorization issued with a development component must include a validity period for that portion, whereas the operational components do not require validity periods. Regulation 26D3 reads, an environmental authorization must specify the conditions subject to which the activity may be undertaken, including conditions determining a distinction between the portions of the environmental authorization that deal with operational and non-operational aspects, respectively, and the respective periods for which the distinct portions of the environmental authorization is granted, where the environmental authorization contains operational and non-operational aspects. And Regulation 26D2 reads, where the environmental authorization does not include operational aspects, the period for which the environmental authorization is granted, which period may not be extended unless the process to amend the environmental authorization contemplated in Regulation 32 is followed, and the date on which the activity is deemed to have been concluded. After reading Regulation 26D2 and 3, can you see how scope and validity period are closely linked? A validity period must be provided for the development component of an environmental authorization, whereas the operational components do not require a validity period. Then you may have also noticed that the EIA regulations clearly differentiate between those activities which have a development aspect associated with them and those activities which also have operational aspects associated with them. Let me give you an example. Listed Activity 1 of Listing Notice 1 reads, the development of facilities or infrastructure for the generation of electricity from a renewable resource. But Listed Activity 2 of Listing Notice 1 reads, the development and related operation of facilities or infrastructure for the generation of electricity from a non-renewable resource. The listed activity for the generation of electricity from a renewable resource does not include operational aspects, whereas the listed activity for the generation of electricity from a non-renewable resource does include operational aspects. And it's quite understandable if you consider that the negative environmental impacts associated with operating a coal-fired power station are going to be far more significant than those of an array of solar panels. So in this case, both the development and operational aspects should be assessed and require authorization. Where listed or specified activities without an operational component are proposed, that is, the wording doesn't include and related operation, then the BA or EIA cannot and must not include operational impacts and associated mitigations. It can, however, include post-construction monitoring requirements like the rehabilitation of a construction site. And Regulation 26D2 makes it clear that environmental authorizations without an operational component must have a limited lifespan and lapse once the construction and post-construction phases have been concluded. In fact, it is the applicant's responsibility to put forward a validity period based on the proposed development timeframes as planned for by the applicant. So the basic assessment and environmental impact assessment reports for those activities without operational aspects must include a period for which the environmental authorization is required and the date on which the activity will be concluded and post-construction monitoring requirements finalized. If an activity has commenced, then it is possible to extend the period for which the environmental authorization has been granted by a further maximum period of 5 years. However, the application, which follows a Part 2 amendment process, will need to be submitted before the environmental authorization expires. If the environmental authorization has lapsed, then the applicant will have no other choice than to undertake a basic assessment for listed activity 32 of Listing Notice 1, which reads the continuation of any development where an environmental authorization has lapsed. And that's it. I hope this has been helpful, and thank you so much for taking the time to watch it. If you have joined our membership program, then you will receive an additional video. We explain the holder of an environmental authorization's legal obligation to audit his or her environmental authorization and EMPR. That's an environmental management program. If you haven't joined our membership program yet, then check it out on Patreon. Otherwise, if you're looking for a consultant to help you with a once-off project, you're welcome to visit our website. Hey, check out our previous video. We explained a few of the identified geographical areas, including international conventions, water courses, heritage sites, and biosphere reserves. The next video, we explain a poorly applied aspect of EIA's need and desirability. It really is quite important. Don't miss it. Subscribe, click on the bell notification icon. If you want to help spread the message, like the video. Keep strong. God bless.